Hey y'all, how y'all doing? Happy birthday to you. Now those who just joined, if you're not a subscriber, please subscribe to the channel. I always ask them how they doing. But y'all look, I wanna get into I wanna get into this Naziah Harris suspect murder case appears in court today. Now y'all pay attention to everything that I told y'all. Pay attention to everything that I told y'all, okay? Cause they about to trick y'all. I told you that. I told y'all that. But what's gonna happen right here, y'all? It's just not this not a trial. This is a hearing, okay? It's not a trial. They raising a issue with regard to an outstanding discovery on the case, okay? Now, but it's about the homicide charges. So they're gonna they filed in a 4478 and what's the other number? 6232. But that's the motion. But look, Jarvis Butts is going to stay muted. He don't want to talk. He don't have to talk. He still continue to plead not guilty. Of course, he gonna plead not guilty. That's what they do. Now, and his guilty, not guilty will enter on his behalf. Now they're gonna be talking about a different motions ending in 6232. For the sake of privacy, they had a witness, a complaining witness, okay? And the complaining witness, we're gonna take it from there. And what I'm gonna do, y'all, I'm gonna stop the video because right now I'm gonna react, okay? So I'm gonna stop and I'm gonna start the video. If you want to look at the whole trial, I do have it on here, but not right here at this time. Thank you, and make sure y'all like and share the video, okay? There was a witness called. The complaining witness was the only witness called to testify at the time. She was it happened to her at 4, but she 13 now. Now y'all, 4 and then 13 taking the stand. They're gonna have to tell her something. They're gonna have to give her some information because she's not gonna remember all that at 4 years old. But the information, somehow they're gonna do it. But let's take a look at this, y'all. Man, he looked like he been in the refrigerator eating. See why they kept the change on it? That's Jarvis Butts, people, for who just joined. Now, y'all, look, listen, from what I just heard, she's 4 years old. How long was the mama in the bathroom at the time? Good Jesus. For him to do all that, how long was she in the bathroom?
She took off her clothes, and Mr. Butts touched her. I believe the order of touching her was he touched the top of her thigh, and he touched under her breast, and then she said he touched her where she peed. Okay. That was the sole testimony of this witness. At the end of the proofs, the prosecution moved to bind over on an original count of criminal sexual conduct in the second degree and added a count of criminal sexual conduct in the first degree because of the statement of because of the statement of complaint witness. Your Honor, I believe that is an abuse of discretion. The only thing that we have on the record is she said she touched where she uses the restroom, and the only clarification we had was she said this is where she peed or she urinates from. Excuse me, those were her words. From that, we had the prosecution postulating that meant that there was some penetration, except there was no penetration mentioned. There was no penetration discussed. We know from case law, for a CSE 1 to happen, there has to be some form of penetration, even the slightest. Case law also tells us if she testified that he were to force her underwear inside of her, that would be sufficient for penetration. Yeah, we don't have any of that. We never have conversation, we never have any testimony about her panties being outside. We never have any testimony about her panties being forced in her. We never have any testimony.
Okay. Now, I have a question to ask. When Jarvis was released at that time, when he got out of prison the first time, wasn't he given command what to do? Wasn't he given a written information not to be around kids and what not to do, so nothing like this will occur? Now he's speaking of. We're gonna use some words like Fanning's been forced in her. This if it wasn't mentioned in the testimony, why y'all just bringing that up now? Why y'all didn't say nothing about that then? Boy.
Anyone penetrating her. Now, that is, given the fact that she was 4 years old at the time this happened, granted, but at the time of the hearing, she was 13. Surely she could testify. I believe she was asked on regular, she remembered the events. She said she.
Okay. Look, y'all, listen. Just like I said, she was 4 when it happened. She's not going to remember all that at 4. So, when a situation right here happens, dealing with age differences, how do the court proceed with coaching the 13-year-old about the situation? Because she wouldn't remember all of that. Now, I'm questionable with the mother. Now, I got a question about the mother now. I want the mother to testify. because she left her baby around the monster.
Remember the events. None of that was testified. I think to say that there was sufficient evidence on the record that says that there was a penetration for the purpose of the CS1 is an abuse of discretion, and we believe that should be dismissed.
Thank you. And counsel, your respective motions, they're similar in nature in that you're arguing the issue of whether or not there's sufficient evidence on the issue of penetration on both your motions at once, correct?
Correct.
Okay. Do you want to, why don't we have him argue his second matter, and then we'll hear one response from the people, if you're okay with that?
That's fine.
Okay.
Okay, so this is then with regard to the case ending in 24101. And sorry. Okay, and this is Lauren Butler, P 88126 again.
Thank you.
So first, to overview the facts from that case, I want to emphasize that this is only with regard to one of the two instances described. The complainant described two instances, but only one of them has been charged as first degree. And I am only arguing with regard to that particular charge.
Okay, y'all. What's going on? Jarvis is trying to get those charges dropped. That's what charge he trying to do. Jarvis having never been in a situation so serious. And they wanted to know, how did you get to the first degree if it wasn't proven in the testimony? When he, he want them charges changed. Jarvis want to come out of there. But I don't know yet. So now they're going to speak on different, particular charges. That's what she's doing now.
So at the preliminary exam, for that instance that was described, the testimony included wearing panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. The prosecution had the burden at the exam of establishing evidence of every element, and that included penetration. And again, the case law is clear on this. In particular, the case I cited in my motion, People Leave in Peace, while that is unpublished, is particularly relevant because it highlights this distinction where it needs to be more than just, it uses very similar language to that used in the exam here with this emphasis on touching the vagina, rubbing the vagina. That's not enough for penetration. And there was even a specified testimony about under the underwear and over, and yet even with that fact, the court still held that this was not penetration. And that's similar to what we have here, this description of some degree of touching of that area, but that alone is not penetration. It also relies on published case law, People v. Payne. Rubbing one hand, where it concludes that rubbing one hand over another vaginal area.
So y'all, what they trying to say is, what, in other words, what this got to do with his charges, that those high charges that they put on him? What does that got to do with it? They making it most simple as he trying to get the charges dropped. That's what he trying to do, y'all. That's what he trying to do. I'm not gonna play with y'all. He trying to get the charges dropped, saying that the grief that they gave him is too high. So the defense job is to do what they do to try to get it off, dropped.
Penetration. And I'd also like to address the response from the prosecution to this motion, because the argument they're making was not reflected in the preliminary exam testimony. Specifically, there was no testimony about inside the vagina. So while they're now arguing that that is possible, is not the testimony we heard. We didn't hear this contrasting of the labia and the vagina. And this diagram that is now referenced in the motion was not used in the exam. So in conclusion, the prosecution did not meet the probable cause standard for first-degree criminal sexual conduct because there was no evidence of penetration.
All right, prosecutor. See, to me, y'all, I'm going to be honest with you. And I've been saying this. Now I don't know, but this I don't know about the little girl. This is the other little girl they speaking on. They are not speaking on Nazaria, y'all. They speaking on the other young lady on the other discovery 6232. Jarvis is trying to drop these. I know I don't say that 50, 11 times, and I'm going to say it 100 times if I help to. I don't know the law and the rules to how to omit these charges in a situation like this because I usually don't cover cases like this. But what they're accusing him of, if they say pen, so I'm going to use for penetration, we're going to say pen. For that, there's no evidence of that, and that make that degree lesser. If it was the pen, then that cut up that charge, but there's no evidence. Okay. And as long as he in jail, y'all, he gonna be doing time served.
And bind over was not proper, specifically as to that charge.
Thank you. Rder, who's going to take the lead from the table?
That's me, Judge.
Rder, very good.
So I'll start with the first argument made by Mr. Riggins, the complaining witness there, Morbid Survivors Initials PB. She testified specifically that he touched my private part where I use the bathroom with. When asked what comes out, she stated urine. I then asked, tell me about what part of him touches you there. She states his hand. And what does he do? What does his hand do when he touches you there? He states he rubs my private part with his hands. I then clarified, is this on the top part of the sack? And she interjected, said the bottom. And I said, would that be where the pee comes out? She says, I clarified, is that a yes? So in summary, she testifies she's rubbing the bottom part of her private part where the pee comes out. Your Honor, in a motion to quash the
Can I ask y'all something? Maybe y'all can tell me in the comment section. Since the little girl was 4 years old, can we hear what the doctor said? Can we see a physical diagram of what the doctor said when she went to the hospital? Because at that time, that 13-year-old girl, when she took the stand, she was 4 at that time. Can something from the hospital tell us that it did happen? How do you go by that? Because you're supposed to take them to the doctor. And that'll kill all that. I'm going to change that word. That will demolish a lot of things that they are doing now in court.
deference to the reviewing magistrate in this case. It requires an abuse of discretion, which is most deference to the district court. Someone just penetration requires any sort of intrusion, however slight. And we use the term genital opening rather than vagina, so that penetration of the
Right. Thank you.
to establish penetration or criminal sexual conduct in the first degree.
I don't know, y'all.
The complaining witness testified.
I don't know if he's gonna get that kind of charge for that, but it's up to them. You know what I mean? I don't think that's a first degree charge, and I'm not on Jarvis' side. Do y'all think? That's a first degree charge? I don't know about that now.
The defendant rubbed her on her bottom part where the pee comes out. When we think about basic anatomy, we know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there, but we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. So when this complaining witness testifies that he rubbed her bottom part where the pee comes out, she's referring to an internal structure, thereby penetration. The examining magistrate also found that, in her ruling, that for a woman to urinate, it's not on the outside of her labia. That's internal. It would be beyond that. And so she found that it was a question of fact. I don't believe that there's any abuse of discretion by that.
Now I can see the A-B discretion. I think that we need to look at what he should be charged from since he don't did it the second time. You know, and it can be a first degree if he don't did this. He don't been locked up for this before. Jarvis haven't learned his lesson. And he's not going to learn his lesson, y'all. He's not. Because he's a victim himself.
I believe that there's satisfactory testimony, at least to a probable cause standard, for that count.
Don't be peeping at me.
Do you want me to go on to the next one?
Please.
Okay. In the second case, extremely similar. This one is specifically, this complaining witness starts off by saying, you know how somebody would play with you in your sleep, like you would feel them in your ear, like this or something. We don't have what she was demonstrating, but she's playing with her ear. He was doing that to my vagina when I woke up, and I was crying. She stated, I said, all right, when you wake up to feeling something? She said, yes. I asked, where do you feel something at? She says, at my vagina. I said, what do you feel at your vagina? Should I feel like somebody's playing with me? Like, I don't know, like somebody's trying to touch you but not wake you up while he's touching you. And I said, what part of him is touching you? I'm touching you. She said, he's using his hands.
Yeah. This is... You talking about a 4-year-old remember all of this? A 4-year-old now. I'm used to be 4 too. And you saying that a 4-year-old remember all of this? Who coached her? Who reminded her?
She later confronted the defendant about it. She asked her why I was acting so weird towards him. She said, you don't remember what you did to me? The defendant, looked me dead in the face and said, I don't remember doing that, but if I did do it, then I'm sorry.
Don't remember doing that, but if I did do it, I'm sorry.
Again, the reviewing standard is abuse of discretion. And here, similarly, she testified that she felt the defendant at her vagina, that she felt the defendant playing with her, using his hands at her vagina. It's more than just mere contact, mere brushing against a vagina, or just merely touching on top of it. It's an intentional act at her vagina. By stating she felt the defendant's hand at her vagina, she's testifying to penetration. She did not state that she felt his hand on or over her vagina, but rather at her vagina. Again, we look at basic anatomy, Judge.
You know what? I just don't understand, y'all. Maybe it's me. Where did the hospital say? Where is the doctor paper? Is this... How can they prove this? Where is the doctor papers? Because somebody seemed like they coached this little girl. Okay? And it seemed like to me it don't happen again to her. You know what I mean? It seemed like somebody, it happened again to her where she was at an age where she remember, not the 4-year old case with Jarvis. It seemed like somebody else. I'm just saying, y'all. I'm just saying. For her to be 4 and remember this. What about at the age of 8 or 5? Did this happen again? It seemed like she remembers something happened like this at at a later, at an earlier date.
Opening is beyond both beyond or inside both the labia majora and the labia minora. And so because sexual penetration is defined as the labia majora and beyond, the vaginal opening is beyond both the labia majora and minora. And so by stating that she felt the defendant's hands at her vagina playing with her,
Um,
testified to penetration.
I don't know, y'all, because what I'm saying is, why would the mama at? This a long time to leave him with her. And Jarvis, it seemed like the women met Jarvis not even checking in. That's why y'all need to check people background. Because it seemed like they met Jarvis as a cuteness and he Hampson to them and got money. And, a little change, you know what I'm saying, pimping them. And they're not looking at his background. You know what I mean? He made them thought that they looking at the outside of him and and not the inside of him. So to me it look like the women don't know him because they got him around their kids.
Believe that there is satisfactory testimony on the record to satisfy that to the probable cause standard, which is again, probable cause standard is the lowest standard, and abuse of discretion is the highest deference to the examining magistrate.
Right, I can see that. I can see that. The lowest discretion and the highest deference to the examining magistrate. I don't hear what the judge got to say.
And I believe that they both create questions of fact.
Thank you. And the best.
Your Honor, in all seriousness, we're giving far more biology of the human anatomy than we have to put on the record at the preliminary examination. All we had at the preliminary examination both they were touching at the area. We have young ladies who, although at the time this happened, may have been too young to describe the actual part. At the time of the preliminary examination, surely they could have said, he touched me on the inside. He forced my panties aside. He touched me on the inside. And in either case, was that testimony ascertained, that testimony was given, that question was asked by either people. So here, all we have is hyperbole. This is what the
Right.
witnesses must have meant when they said that. Yeah, I think that is a far reach, and I think surely that's the abuse of discretion to just simply say they must have meant there was internal penetration. That is an element the prosecution has to prove in each and every case when they charge a CSC in the first degree. In
Right.
either case, was that proven? Was that ascertained? We just have speculation, and to put those.
See, that's what I said. That I just said that. I'm not trying to take up for Jarvis, y'all. But when somebody go down, when I do my court cases over here, if I'm gonna take somebody down, I want to take them down the honest way, the right way. All the prosecutor did was speculate. Well, it's the proof. That's why I said, where's the hospital papers? Anybody can come up there and take the stand and say, oh, Jarvis but did this and did that. Where is the hospital papers? Did she take her child to the hospital? So if she can't prove that, how do anybody supposed to believe something you can't prove? It's speculation.
Charges in front of a jury would simply be wrong, Your Honor. So we're asking you to grant both motions to quash.
I would just reiterate what he is already saying. I think in my case in particular, there's this emphasis on the word at. There's just no, it's not realistic to say that that's what at means. This comparison
Now this go back to one of my.
We're looking at pertinent portions of the transcript,
Hold up, y'all.
namely transcripts. Of course, the prosecution at the preliminary examination has the burden to show competent evidence that probable cause exists.
Now I asked that question about the competent evidence, about the evidence. Now with Naziah Harris, there are probable causes. But we're not talking about Naziah right now. And the judge got to remember that the probable cause that we heard on our end was for Naziah. Now for that little girl with the probable cause, I don't know about that, y'all. I'm just gonna be honest about that because what I hear from the little girl, from what the 13-year-old said, like she was coached to say that because if that happened to her at 4, let's get all the CPS paperwork. Let's get to do the prosecutor have evidence showing that that happened to that little girl at the age of 4. So they need to pull out their paperwork and say that they do have this information to present in front of the jury for that little girl because she got to realize that we don't I don't know too much, and I just heard about what the little girl said happened. Okay, but you got to realize we got to have evidence, proof. Now, if the prosecutors, that what the prosecutors just read to us, is not enough proof to me, y'all, for a 4-year-old. I think that he should have been locked up then behind that situation. Because where's her paperwork? The mama. Where's the mother paperwork? These people ain't doing, to me, they ain't taking this case serious.
So here, looking at pertinent portions of the transcript, and I'll start with the case where he is the alleged complainant. There's a few pertinent portions of that examination transcript, starting on page 15. And it notes, line 20, her answer to question, he touched my private part where I used the bathroom.
The judge act like he's not even familiar with his paperwork. Before I even present something to somebody, I would look over my work instead of looking like this, like I just got my stuff, so I'm gonna read it like that. A lot of people do their work like that. Now he about to sit here and read another portion of the transcript. For a 4-year-old at the time to say all of this is I don't understand. I don't. And what I mean, y'all, listen for y'all, get your blood pressure up. What I'm saying is, at that time, where is this child paperwork that mama called the police and took the child to the doctor and called the CPS people? Where's those paperwork? It will prove a whole lot than situation that they about to take this child through. Excuse me. In this putting her on the stand and stuff.
Okay, and when you use the bathroom, what comes out? Answer, urine. Question, urine. Okay, tell me about the part. Tell me about what part of him touches you there. Answer, his hand. Question on the following page. Okay, what does his hand do when he touches you there? Answer, he rubs my private part with his hands. Question, okay, was this, so when he's rubbing your private part with his hands, is this on the top part? Answer, the bottom. Question, the bottom part, okay?
They already said this.
Question, okay, and is that where the key comes out? Answer, yes. With regard to the file where the alleged complainant is 18, directing the attorney's attention to the pertinent portion of the testimony on this issue of penetration, page 83.
Oh, page 83.
Expect an answer reading, and you know how you like how somebody would play with you in your sleep, like you would feel them. And I think the pertinent part of this answer that's relevant to this determination is the next three words. And again, it's like you would feel them, quote, in your ear, like this or something. He was doing that to my vagina when I woke up, and I was crying. Moving to the next page, page 84.
Y'all, I'm gonna tell y'all something. This little baby been having nightmares. It seemed like she had nightmares and she been going through something, and I went through it again after Jarvis. That's what it sounds like, that this happened to her at 8 or 9 too, y'all. Something ain't right about this. She's telling allegedly some on Jarvis, but it's seems like somebody else she talked. I don't know. That let Jarvis did it more than one time. I don't know. Because something happened to her. But a 4-year-old wouldn't remember all this. So that's why I said, where's the 4-year-old paperwork? Evidence. Doctor. CPS worker. Police. Where all that paperwork at? He on page 84. Jeez.
Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad? Answer, yes. Moving to page 85, line 8, question.
What? So this is his daughter talking? Let me back this up. Y'all listen to this question. Is this Jarvis' daughter? His own child? Because she said she was sleeping with her dad. Her dad is her dad. Okay.
Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad? Answer,
You see that? Jarvis.
yes. Moving to page 85, line 8, question, all right, and when you wake up, you kind of wake up to feeling something. Answer, yes. And where do you feel something at? Answer, my vagina. Question, what is it that you feel at your vagina? Answer, I feel like somebody playing with me. Like, I don't know, like somebody like trying to touch you, but trying not to wake you up while touching you. Question, okay, do you know what part he is using to touch you? Answer,
A 4-year-old?
his hands.
How?